16/5/2016. Arising out of Dimapur West PS case number 95095/2016 under section 120B 420 406 471 IPC. Stop. The case of the petitioner in brief is that on 16/5/2016. Okay, this is 2016 case. Charge sheet filed on which date?
Charge sheet is filed in 2019.
19.
Lordship.
2016 case, charge sheet filed only on 19.
19, Lordship. On 14/8/19.
19. And then from 19, this was the first order by the JMFC, 31/10/2022.
No, Lordship.
Is this?
In between, Lordship, there must have been some proceedings, Lordship. But, since I'm not.
Okay, but then charge not yet framed.
No, Lordship.
Not yet framed. Okay.
That's why the petitioner has filed discharge.
Okay. That on 16/5/2015. Who lodged the FIR?
The complainant, respondent number 2, Lordship. The
What
FIR
is
is
the
page
name?
11. The FIR is page 11. Newmai.
Name?
Wimathon Newmai.
Nimathon.
That is page 11.
Wimathon Newmai. So
Yes.
Wimathon Newmai. Lodged an FIR before the officer in charge, West Police Station, Dimapur, against the accused applicant, inter alia alleging therein that what is the basic allegation?
That he has ordered one laptop.
Where do we find?
That is paragraph 2 of the FIR, Lordship. On 26th November 2015, he called us saying that he's from the nation so-and-so, a genuine distributor of Gauhati, and
Okay.
we transferred so-and-so to purchase a laptop. That's it.
That on 26/11/2015, on being asked by the accused applicant, they transferred rupees 19,012 rupees
In the account of the petitioner.
in the account of the accused petitioner, being the
Amount of the laptop.
consideration amount of the price amount of laptop. However, the accused applicant did not send the laptop On the other hand, they found that the accused applicant have been duping many people, many other dealers in the same manner. So, basing on the above FI, the case was registered being West Police Station case number 095/2016 under section 120B 420 406 471 IPC and investigated into staff. Para. After completion of investigation and on being found prima facie case against the accused along with two others,
Along with four others, but one was discharged.
four others have been charge sheeted for offense under section 120B 420 406 471 IPC. Stop. Where have you annexed a compromise agreement?
Page 14, Lordship.
Page
14,
14.
page 14 and 15.
This
Lordship.
was entered before the filing of charge sheet,
On 22nd of August 2016, Lordship.
2016 only. Okay, stop. Para, huh?
Before the charge sheet, Lordship. Charge sheet was filed in 2019 only.
Okay, however, before. Para, huh? So this agreement, the compromise deed was also presented before the IO of the case.
Lordship,
Okay,
But
despite of
what-
this agreement, the IO carried on
the
the
IO did not-
investigation and filed charge sheet.
yes, Lordship. The IO did not.
So whether in the charge sheet anywhere, whether this IO has mentioned about this compromise deed,
No, Lordship.
nowhere.
No, Lordship.
This was in the 2016 only, but then charge sheet filed only in
Lordship,
the
Lordship,
2019.
if we can see from one of the charge sheet here, page 23, that
Hmm?
page 23. Or should we
What is
come
it?
to page 23? That is a part of the charge sheet.
Hmm.
Paragraph 1, 2, 3, 4, 5. Paragraph 5. Copy of detailed report and accused discharge report enclosed as annexure. Meanwhile, during investigation, I was transferred from Dimapur, India for this incident case investigation was reimbursed to
In the
one
meantime,
one
in the
ACP.
meantime,
So,
during the
Lordship,
investigation,
during the transfer and the handing over the
During
file,
the
they might have
investigation.
misplaced it.
before filing of the charge sheets, the accused applicant has entered into a compromise deal with the informant on 22/8/2016. As per the said compromise deed executed, sorry, between the informant and the accused applicant. The case was compromised and settled between the parties. And the informant was paid back his amount of rupees, paid back his money amounting to rupees 19,012 rupees. Which was received and acknowledged where it is stated that the case will be withdrawn. He has no further grievances. Where have they stated?
Lordship, at page 14, para 1, 2, 3, 4, 5. And whereas on the approach and request of the second party, the first party taking into consideration of the request has consented and agreed to compromise the case outside the court on being payment of the complaint amount, thereto also agreed to withdraw the case on amicable settlement on the following terms and conditions.
The informant agreed to withdraw the complaint laws against the accused applicant. Stop. However, the said compromise deed was presented to the eye of the case. However, the eye of the case carried on his investigation and submitted charge sheet against the accused applicant and along with 4 others on 14/8/2019. That is after about 4 years of the filing FIR. It is the further case of the petitioner that on the process was issued against the petitioner. However, the cases, however, no charge. Case is not yet started. Charge not yet framed.
No, Lordship.
The trial of the case is yet to begin as the charge has not yet been framed against the accused staff. However, on 31/10/2022, the accused applicant made an application before the learned judicial magistrate first class, the learned trial court, that is within bracket, judicial magistrate first class, Dimapur, praying for his discharge. So all of them made application or only the present applicant? Whether discharge application was made by the present applicant only or by
only the present applicant, Lordship. Yes, only the present applicant.
Okay.
Lordship may see from the order dated 31st 10/2020. I mean, accused DJT present, along with the counsel, co-accused Mantu Patagre and Aminesh Goswami are absent.
Made an application for discharge staff. However, the said application, discharge application was rejected on the ground that the compounding the scope of on the ground that the scope of compounding the case by the subordinate court is only limited to the list enumerated under section 321 and 2 of the CRPC. And as the offense charge sheeted against the accused applicant is non-compoundable offense, it is not within the power of the subordinate court to discharge. So, the respondent number 2, informant, appeared and filed affidavit and stated that the contention made by the petitioner in paragraph 4 is paragraph 4. What is paragraph 4? That the case has already been compromised and settled, amicably settled between the parties on 22/8/2016. Is correct, true and correct. And since the matter has already been amicably settled between the parties, and he has received his amount of rupees 19,012 rupees from the accused applicant, being the payment made to him earlier as the cost of the laptop has been received back, comma, the petitioner has, the respondent number 2, with informant, has no further grievances against the accused applicant. Para the Nana PP, Mr. Jimomi submits that. Oh, sorry. I'm very sorry. Submits that the allegation against the accused is more than what it looks simple in the FIR, as it is, as the accused has been, as there is the accused and his associate has been duping the other people as well. In this other people as well, for supply of or what?
Lordship, there is the statement given by the accused
Okay.
before the police and not before the magistrate. Moreover, if the IO,
However,
if the IO has stated in the charge sheet, the IO should bring in record. In those 3.5 years, the
there is also
IO could not bring anything on
there
record.
is also report of
Any
some
complaint, other cases
against
registered.
the accused applicant. However, insofar as the case of the petitioner with the informant, respondent number 2, informant is concerned, it appears that it appears that they have entered into amicable settlement they have amicably settled the matter by executing a compromise deed whereby the accused has stated to have paid back rupees 19,1200 to the informant. Okay. Learned counsel for a parties. Rest all details.
Blush. Blush moment.
For orders, item numbers 10 and 11.
No one appears on behalf of the parties. Case is stand adjourned. List this matter after 2 weeks. Okay.
For orders, item number 19.
Please, Lordship.
Yes.
Lordship, by order dated 23/4/2024, we have already taken steps through registered lady. We have already taken steps through registered lady
Okay.
to all the respondents.
It is still awaited. No one appears on behalf of the respondent. Okay. Okay. Mr.
Sugajish, Lordship.
Learned counsel for the petitioner who submits that he has taken steps upon all the respondent by a registered post.
Yes, Lordship.
However, no one appears on behalf of the respondent. The petition respondent. Whether the Global Open University is a government,
No, Your no,
Private.
Your Lordship.
private,
Yes, Your Lordship. But I've stated in my
whether the writ lies against this.
yes, I've stated in my paragraph 2 as well as in my paragraph 11. I've stated in my paragraph 2 as well as in my writ petition. Paragraph 2 as well as in my paragraph 11.
So according to you, writ lies against the university.
Yes,
Paragraph 2 and
paragraph 2 and 11. As well as this honorable court has disposed of the same matter, which is at my paragraph, which is at my next year at page 27, relating to same matter. This
Same
honorable
matter.
court is yes,
disposed by this court.
yes, Lord. Page 27 of my next year L.
Same matter for non-payment
Yes,
of
Your
the
Lordship.
salary
Yes, Your Lordship.
directed to pay.
Yes, Your Lordship.
Okay, let them appear then.
Okay.
Okay. Yeah. Taking records, the return service still awaited. In view of the above, this matter after 3 weeks.
Okay, Your Lordship. Obliged, Lordship.
for hearing item number 27.
This Lordship.
Yes, please.
Lordship, the other day, the hearing of the parties almost concluded. Only on a point of law, question of law, the issue was kept. Lordship wants certain assistance. The issue was, Lordship,
What was this matter about?
by Malot, the land in Mokokchung, that Sun Rifles issue.
Yes, yes, okay. The brief is that the lane, this is lane at Mokokchung.
Yes, TC Hills, Mokokchung, Lordship. But can you allow me to give a brief?
Yes, yes, please.
That the land at TC Hills at Mokokchung. Now, Manoj, the settlement orders were issued in favor of one, Mr. Susang Jamir, advocate, and
Yes.
approved. Then thereafter, Pata was issued in favor of Susang Jamir.
Yes.
Then it was transferred to me to present to the plaintiff.
Right.
And thereafter, eviction notices were issued by the STU Civil as well as ADC Mokokchung to the Assam Rifles to vacate the area. On the ground that some dilapidated structures are existing there. Thereafter,
Eviction notice was issued to the
Assam-
LOT.
no, to the Assam
Oh,
Rifles.
sorry, Assam.
Underground,
Because you want to.
yes,
Under.
because when we were when we started developing the area,
Okay,
we started obstructing.
Okay, yes.
So
Yes.
so eviction notices were issued first by the SU Civil Mokokchung, then ADC Mokokchung.
Yes.
Then, my lord, thereafter, he also replied with a show cause notice, but he did not challenge the show cause notices for eviction.
Right.
Then we filed the civil suit before the learned court below. On the ground that settlement, that I derived the title on the basis of the civil settlement order issued by the state government, allotment orders, and the permit given to me. The respondents appeared contested the case under lower court and German, but he did not challenge the settlement order issued to me. The only contention was that it was issued behind their back, so it is illegal and not applicable to them. Then, my lord, the title and possession was handed over to me by the judgment, the degree. Then this is the appeal before the honorable court. Now,
Appeal is filed by?
by the
Yes.
by the Union of India,
Assam
by the
Rifles.
Assam Rifles.
Yes.
So the grounds were given.
Mm.
The main issue was that since the title was not challenged, which was allotted to me by the government.
Yes.
When that is not challenged, what right the appellant have? That was a pointed question your lordship
Right.
asked the other day,
Right,
if your
right.
lordship, if your lordship remembers. Now, in course of hearing, then the hearings were concluded by both the parties, your lordship.
Right.
Then in course of hearing, 11 issues were framed, but on the issue of title,
Yes.
my lord, clear findings were given by the learned court below.
Mm.
However, with regard to position, he only discussed the matter and he did not give any findings.
Right.
So the lordship asked a pointed legal question.
Mm.
When the learned court below did not keep his finding to all the issues framed, then what happens? And Lordship
Right.
wants zero the assistance. That's how the matter was kept part third and 13.
Right.
Otherwise, from the parties, Lordship, the hearing was facts.
Yeah.
And the merit of the case, hearing concluded only on that low point.
Yes.
So, my lord. So I will only, so my lord, we are only confining to that low point when the issues
Are not being discussed by the trial.
to discuss, but no finding.
Yes. No finding. Yes.
He did not give findings on position.
Right.
I'll point it out to you to refresh your lordship's memory. So then what happens? That is the only issue your lordship wants to clarify. Now, lordship. So for that purpose, lordship, just if your lordship will kindly come to the judgment. Lordship may kindly come to page 24 of the judgment. Straight, just to refresh Lordship's memory.
Yes, please.
Issues frame.
Hmm.
May I read page 24?
Page 24. Yes.
24. This is part of the judgment.
Yeah.
One, whether the suit land was allotted to L. Susang Jamir by land settlement order.
Which
dated-
one? Where are you reading?
Page 24, Lordship.
Page 24. Yes. Sarah? Which one?
Issues frame, Lordship. It is with the head note.
Issues friends. Is issue number 10. 11 issues.
My lord, it is page 24 in the paper book. In bold letter, it is written 18 also on top. 18 and on the right hand, it is written in small letter 24.
Then it is
That's
24
in
is something else. This is 24, but then something else. Then,
It should be 18.
right.
18 with all black letters, Lordship.
Yes.
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 Issues frame.
Yeah.
One, whether the suit land was allotted to Susang Jabir via land settlement order dated 1978. Number two, whether residential permit 2045 issued by the municipal council to L. Susang Jamir. Three, whether the plaintiff had purchased the suit land from Sri Imnang from Sri Imnangashir, Tata and 7 others by sale date 6 August 2014. Whether the defendant number one in unit of India were in continuous possession and occupation of the suit land since 1889. Whether the letter dated 18 July 1978 issued by the Revenue Department as well as a land settlement order dated 18 October 1978 issued by the Deputy Commissioner Mokokchung in favor of Mr. Susang Jamir. Whether the sketch map in respect of suit land prepared by the land record in survey officer Mokchung dated 4/5/2015 approved by the state authority, whether the defendant 3 and 4 are competent to allow the said plot of land in favor of the plaintiff, whether the defendant Union of India have raised any objection against the settlement order dated 18 October 1978, whether the issue civil Mokchung directed defendant number 2 to dismantle the old building and to vacate from the suit land on or before 21/3/2017, whether the plaintiff was served legal notice dated 1/6/2017 to the defendant, whether the plaintiff is entitled for any degree relief. These are the 11 issues framed.
One more thing. That is, of course, the one query. And another query probably was that. So since the Assam Rifle was issued eviction notice. So that indicates that the possession was with the Assam Rifle
My lord,
at the time.
I'm coming to that.
Yes.
I'm coming to that.
Yes.
I'm coming to that.
Right.
I'm coming to that. No problem. No problem. I'll clarify those positions. So those are the issues. Now, issue number 1, paragraph 9.
Yes.
Whether the suit land was allotted to Susang Jamir by land settlement order dated such and such. My lord, there's a finding that it was issued to Susang Jamir. There's a finding in item issue number 1. There's at the outset, it may be stated the instant suit was filed on basis of land settlement order, which was approved by the such and such in the name of such and such. The statement deposed is corroborated by the defendant, lone witness. Then, Lordship, next page. I will be very fair where I have not, whether there is a finding, where there is no finding, it was discussed the other day also, just to refresh your Lordship's memory.
Right.
Then, number 2. issue number 2, 3, and 5, whether issuing residential permit number 2045 issued by the Municipal Council of Susang Jamir, the residential permit was issued by the office of the such and such in the name of, and the same was renewed till then. So 2, 3, 5, there's a finding. Then, my lord, issue number 4, whether the defendant was in continuous possession and occupation of the suit land since 1889. My lord, there is no finding here. Only the submissions were recorded.
Yes.
I'm giving it, so that there I'm coming.
Yeah.
Then, my lord, issue number 6, whether the sketch map in respect of suit land prepared by the land record Bokchong stated such and such approved by the state authority. See the paragraph 11. The sketch map in respect of the schedule of suit has clearly been shown by the land records Bokchong, and the same has been subsequently approved by the state authority. So this is a decision finding. Then, my lord, 7 and 8, whether the defendant 3 and 4 are competent to allow the said plot of the land in favor of the plaintiff, and whether the defendant Union of India had raised any objection against the settlement order dated 18 October 1978. My lord, there is no finding. He has discussed, but there is no finding. Then, my lord, 14, whether the SUC Mohokchung directed number 2 to dismantle the old building and to vacate the land from the suit land on or before 31/3/2017. My lord, there is a record. My lord,
Which one?
page serial number, issue number 9,
Oh, sorry,
paragraph 14.
Yes, yes.
Then, my lord, lordship will come to the paragraph 14 to the bottom. Subsequently, the additional commissioner, the deputy commissioner, directed the commanding officer to dismantle the deliberated structures at the site which belong to the plaintiff within a period of 15 days. So, issuance of my lord, notice for vacations. Page 22, lordship. 23. 23 on the bottom, second paragraph. So it appears there is a finding that eviction notice was issued. Last paragraph, subsequently the additional deputy commissioner.
And directed to the commanding officer of 44 the Samurai Road. Concerns to dismantle.
So, my lord, when the eviction, since eviction notice is issued, it is apparent that part of it were under their possession. There is no dispute.
Yes.
Because unless 2 eviction notice is issued, so that is not disputed. Now, I'll come to that point again.
In the notice, let us see the notice,
Yes.
what type of notice they have issued,
My lord,
whether they have declared that they are
kindly allow me to
unauthorized
conclude.
occupied.
Allow me to conclude this, and I'll go to
Okay,
that.
okay.
Then, last,
Hmm.
page 24, serial number 15.
Hmm.
Whether the plaintiff served legal notice to the defendant. So, my lord, that is not disputed.
Yes.
Now, my lord, I will come to the, my lord, lordship may kindly come to annexure 8 page. Lordship may kindly come to page 50. Lordship may kindly come to page 51. Yes, my lord, pagination, mine is that I'll kindly appear with me once.
There's a prayer portion. For what is it?
That is, no, sir, page number 82, I'm sorry. Page number 82. Yes. Page number 82. 19, Paul letter, there's a confusion. That's why my pagination, there's a confusion, lordship. In Paul letter, it is 90, on the right hand, it is 82.
Yes.
My lord, may I read? This is 23rd February 2017. Subject, dismantling of structure in the site of Srimati such and such. Reference above, I'm directed to request your authority to dismantle the structures at a said site. We mentioned that those abandoned and dilapidated buildings are located at a site that belongs to Appellate who wishes to begin construction of a residential building on the spot. As these structures are presently under your custody, your kind office is requested to dismantle the same or given permission to the landowners to do so on or before the 21st March 2017. This is the first notice.
Without saying that it is an illegal occupation under them.
My lord, dilapidated ones located at the site that belongs to Lordship Mechanism.
It belongs to says, but
At the site, when he said it belongs to me,
it doesn't belong to him.
it doesn't belong to him.
Hmm.
It only says located at the site that belongs to Srimati Appellate. My lord, third line. Then Lordship Mechanism come to page 84.
Page
Page 84. The second
24,
84.
84.
My lord, it is written 92 also, 84 also. The second notice.
Yes.
With reference to your office letter dated 23rd February, I am directed to remind your authority to dismantle the dilapidated structures at the site that belong to Appellate within a period of 15 days from the date of issue of this reminder to your authority. It may also be reminded that a legal notice has been received from Appellate to Tunjin Gaba Advocate to institute legal proceedings in the competent court of law if the said dismantling works are not carried out within the stipulated period. Therefore, your authority is reminded to carry out the necessary action at the earliest. These are two legal notices. Lordship, the other day, it was submitted that this legal notices has not been challenged.
Not been?
Challenged.
Okay.
Now, Lordship, to that, Lordship, you kindly see the judgment. The judgment. Judgment page number. Page number 26, Lordship. Page number 26. To the judgment, paragraph 16.
Page 26.
Page 26.
Yes.
May I read paragraph 16?
Yes. Please.
That the defendant, the state of Nagaland, have also filed a written argument. It admits and supported the evidence made in the plain. Learned counsel, Minister such and such, government pleader appearing on behalf of the state defendant submits that she would rely on the written gist argument that has been filed and fairly submits that the settlement order was legally issued and the same was approved by the government. Therefore, the plaintiff have the interest over the suit land and submits that once the settlement order is issued to the person, he becomes the owner. This is the stand of the state government.
Where says Learned counsel, Miss so common pleader? Okay,
Yes. Yes. My lord, unfortunately, the state is not a respondent, is not made a respondent in this case. So in the appeal, so they are not aggrieved by the decision of the state government. Lordship may kindly see. Plain copy. Plain copy, that's why. Page number, my lord, Lordship may kindly see the plain. Plain is at page 34. Who are the respondents?
Yes.
My lord, Civil Suit 1 of 2018. Lordship is on it. Then respondents, Director General, Commandant, State of Nagaland, Deputy Commissioner, and private respondent, one Mr. Imnang Rashid Takar. So those were the parties before a learned court below. And 16, paragraph 16 is the stand of the state government, which we have just referred. Now, Lordship, may kindly come to page 1, page 2.
Just a minute. Paragraph, yeah.
My Lord, paragraph 16 of the judgment which we have just read, that is the stand submission of the government leaders before the learned court below. That there is no discrepancy, not in the settlement order. That was the stand accepted by the court. Now, Lordship, may kindly come to page 2.
Page 2.
Yes.
Yes.
Lordship, may kindly see who are the petitioners and respondents. Only file against the plaintiff. Page.
Okay, this is filed by.
The present person.
Present one.
Yes.
Okay, not the state.
It is filed by the Union of India, not by the state, and the respondent, Lordship, may kindly see only the plaintiff.
Yes.
So what I'm submitting is the state were not made a party respondent. So in other words, the Union of India is not aggrieved by the decision and the submission and stand of the learned of the Union state government before the learned court below. They have accepted. They have not made the state government a respondent because they are not aggrieved by their actions. That is what I'm trying to impress upon your Lordship. And in the judgment, at paragraph 16, we have just read the stand of the 32, which we have just read, Lordship, that the state government says that there is no discrepancies, that the settlement order was legally issued and same was approved by the government, and therefore the plaintiff has exclusive rights, title, and interest. That was the stand. Now, my Lord, the issue. So, my Lord, I'm not repeating all the facts which we have discussed the other day. I'll only confine to the low point now.
Yes.
Now, my Lord, firstly, when out of 11 issues, my Lord, on matters on title, on the title, that is settlement orders, findings were given. Only on the issue of position, only on the issue of position, poor in position, your Lordship has found that the learned court below, that is, did not give, though discussed, the learned court below did not give findings on the question of position. That is issue number 7 and 8, issue number 4, issue number 4, issue number 7 and 8, there is no finding.
Yes.
Issue number 4, issue number 7 and 8, there is no finding that relates to position. That, my Lord, there is no question because we go by the record. So, my Lord, now, Lordship may kindly come to the order of the judgment, page 26. My Lord, paragraph 18. Order. On poll, on the top it is 26. I'm the paragraph 18. May I read, my Lord?
Yes, please.
Considering the submissions of both counsels, and I'm constrained to note that my decision is also in tune with the findings of the Deputy Commissioner Mokchung in a similar case, wherein the present defendants have relied on the same documents as in the present case. It has been affirmed during the course of hearing that no appeal has been preferred against the said decision of the DC Mokchung, and same has not been disputed by the defendants. No materials have been brought to the notice of this court about any appeal revisions. Therefore, it can be safely said that the defendants have accepted the said ruling of Deputy Commissioner Mokchung. Then, Lordship, my findings are also strengthened by the fact that the unconsiderations of the materials available before this court and the submissions of the learned counsel appearing for the parties, and in the absence of concrete evidence, the claim of the Assam Rifles that they have been in possession of the said land is believed by their own statements in the records. So, my Lord, though in the issues, specifically in paragraph 13, and 12, issue number 4, 7, and 8, though he did not give a finding there, there's a finding here. That is what I'm trying to impress upon your lordship, because he says, last 4 lines, it says that in the absence of evidence, in the absence of concrete evidence, the claim of the Assam rifle that he had been in possession of the said land is believed by their own statements and records. Then lordship, you can see the degree pass at page 27. In terms of the above judgment in order dated such and such, the instant civil suit is hereby decreed as under the plaintiff is legitimate owner of the suit land located in such and such, having scheduled lien of such and such. Do the defendants are hereby stopped from any activities on the land suit decreed and plaintiff to hold, enjoy, and possess the suit land without any hindrance, obstruction from the defendants and their agents and representatives. So this is the degree passed. Now, my lord, to remind your lordship, the other day I placed 2 judgments. First judgment says that the concept of adverse possession does not apply to state government and its agencies. That was the first judgment I have relied with. Secondly, my lord, the second judgment I have placed was that any order, the efficacy of the judgment will remain. May I give a judgment again, lordship? Or it is, first was 2011 10 SEC 404. It was read in detail, so my lord, I hope the record lordship has noted down the citation.
Where is the judgment?
My lord, I thought that since it was referred the other day, I thought it was not necessary to refer again. Anyway, lordship, I will.
Okay.
I will. My lord, we are giving the citation, John. My lordship, kindly don't take note of this. Then, since it was referred the other day, I thought it will not be necessary. That's why, my lord.
Just a minute. 2011.
2011 10 SEC 404, paragraph 1, 2, 3,
39.
39 to 47. That is, adverse possession is not applicable to the government in its agency. Then secondly, lordship, 2011 3 SEC 363, paragraph 16 to 19. An order has to be challenged and declared. The efficacy of the order remains unless and until it is challenged and declared void by the court. These 2 judgments, my lord.
The order has to be challenged.
Yes, an order has to be challenged, or an order has to be declared challenged before the court, and the efficacy of the order will remain unless it is challenged and set aside by the court. If necessary, citation, Johnson. My lord, we are giving the citation. So if lordship,
Citation, I think copy not given, I think. Copy not given. Kindly
yes,
supply a
first-
copy.
yes. The other day, your lordship, you had gone through it. That's why we thought we are giving again, lordship.
Efficacy of the order will remain.
Unless it is challenged and set aside by the court, by the competent court. Because, my lord, settlement orders has never been challenged.
Just a minute, one paragraph, text, in support of his submission, the learned counsel for the petition, learned counsel for the respondent submits, cited the decision in the decision of the Honorable Supreme Court in, what is the name of the party here in 2011?
Lordship, I am giving. Not 2011 3 SCC. Lordship, that is,
So and so,
we will give in her in written. Krishna Devi-
versus so and so reported in 2011 within bracket 10 SCC
3 SCC.
404. Stop. Okay.
My lord,
Whereby it says
My lord.
that the adverse possession
yes,
is not applicable in respect of the government and the agency.
yes,
The relevant,
yes.
the relevant paragraph.
State of Haryana versus Mukesh Kumar and others.
Okay. Right, state of Haryana versus
Mukesh Kumar in others.
what Kumar?
Mukesh Kumar.
Mukesh
I'll
Kumar
give the book.
and others. Okay, okay. The relevant paragraph. The relevant paragraph, are 1, 2, 3, 37. Sorry, 1, 2, 3, 39, 40,
39 to 47, Lordship.
39 to 47. Stop. And next, next para. The Planning Council for the respondent also cited, relied on the decision of the Supreme Court. What is it? 2011 is
2011 3
this is
SCC.
party name is
I'm giving, Lordship.
okay. Party name. Party name reported in. Party name reported in 2011 SCC. Three 2011 SCC 363, whereby it is held that an order has to be challenged before the court, right? Whereby it is held that the order is to be challenged before the court. Stop. The efficacy of the order will remain unless it is challenged and set aside by the court. Stop. The relevant paragraph are paragraph
16 to 19.
16 to 19 are reproduced here in below. Okay.
My lord, I also desire to submit another judgment today. May I give it is now afterwards in the
Just yes, give it.
all right.
And then kindly just printed copy,
Yes,
the Xerox copy,
yes, I'll give.
maybe supplied. Okay, yes. What else?
So, my lord, this is then, my lord, Lordship, you kindly see at page paragraph 18, the first part.
Page 32.
Yes, the same the paragraph within which we have read just now. Page number 30. Yes,
Para
Paragraph 18 again, Lordship, the
18,
first
yes.
part.
order.
Yes. Considering the submission of both concerns, I am constrained to note that my decision is also in tune with the findings of the Deputy Commissioner Mogokchung in a similar case, wherein the present defendants had relied on the same documents as in the present case. It has been affirmed during the course of the hearing that no appeal has been preferred against the said decision of DC Mogokchung, and the same has not been disputed by the defendants. No, so my lord, the learned court below has adopted the earlier decision of the Deputy Commissioner, which was placed before your lordship the other day.
Earlier decision of the Deputy Commissioner.
Yes,
It was
Lordship.
placed before this
Yes,
order.
25th May 2007.
Yes.
So, my lord,
What is this?
my lord,
This is
it
one
was,
decision made
not
by
just
the
the
deputy
550 is there on similar case.
Hmm.
Similar and same, and on the same area, my lord, there was a dispute for construction of the office of the deputy commissioner's building. And there the same documents were relied upon, and the deputy commissioner Mogokchung passed this order. They have accepted that the judgment, no appeal was filed.
Okay.
Lordship,
So here in this case also,
same.
the petitioner, the
The appellant.
appellant had a building existing in the lane,
My lord,
in the same lane.
my lord, look, if your lordship, it was, their claim was that they were in continuous position.
So they had a building existing in
My lord,
that plot of land
some
also.
structures were definitely there, and their claim was that you were in continuous position. If your lordship see the judgments, orders, it's all in type copy. It was read in it all the other day on 13th. So
Yes.
to save time,
Hmm.
I'm only making a submission that, my lord, it is covered. It's a covered case.
Okay.
Because since they have not filed an appeal. So accordingly, the learned court below also has relied on this judge order to say that when they have accepted on similar circumstances case.
Okay, just one
is covered.
paragraph. The learned counsel to the petitioner further submits that in the similar nature of case, the appellant has relied upon the same document. What office?
Deputy commissioners,
Where the
Gokchung.
deputy
the site, the present place site where a deputy commissioner's office is already constructed.
Okay. Okay. Relied upon in the case where the present deputy commissioner complex has already been established. In that case also, the appellant relied upon the same document, and the deputy commissioner has decided in favor of the
In favor of the state
state,
and no appeal.
in favor of the state, and no appeal has been filed so far by the appellant.
No, lordship,
So, and thus
the present,
the state case is fully covered. The present case is fully covered with the state case between the state and this was case between, that case was between,
deputy commissioner with the state of Nagaland and the Assam Rifles.
The
okay.
deputy commissioner versus the Union of India decided by the DC in this case.
But since they
But
have
you have not challenged.
since they have not challenged.
I'll come to that.
Okay. So the deputy commissioner versus the state of Nagaland
Versus the Union of India. This is Assam Rifles.
versus
Assam Rifles.
Assam Rifles.
Yes.
Okay, start. So the decision, okay. The decision was made on 25/5/2007.
Okay.
25 May 5, huh?
25,
25/5/2007.
So, my lord,
Okay.
so the principle of res judicata will come into play. Same subject matter has been decided and they have not challenged.
Since the matter involves with the same subject matter and the appellant has not challenged the said order, the res judicata will apply.
Yes. Now, yes. Now, lordship, kindly allow me to come to order 20 of the CPC.
Yes. Order 20,
Order 20 rule, order 20 is judgment in degree. Lordship has found it.
yes.
Now, my lord, I am reading Order 20, Rule 5.
Rule 5.
Yes.
Yes.
Near it, my lord.
Yes. Please.
Court to state its decision on each issue. Lordship is upon it.
Yes.
In suits in which issues have been framed, the court shall state its finding or decision
Yes.
with the reasons therefore
Yes.
upon each separate issue,
Yes.
unless the finding upon one or more of the issue is sufficient for the decision of the suit.
Yes. That is what your issue number 478.
So my respectful submission, my significant issue, so my lord, my respectful submission before this honorable court is that it comes within the exception unless the finding upon. Because my respectful submission is that there is a clear finding on the settlement order. There is a clear finding on the title.
Yes.
So, my lord, once the title is decided, because lordship, you see, upon each separate issue, then unless the finding upon one or more of the issue is sufficient for the decision of the suit.
Where is the sufficient for the decision of?
My lord, my respect,
Yes, yes.
it is a subjective finding of the court, personal submission of the court, my respectful submission, that's why I'm making a submission. That once the learned court below had come to a finding that, look, this is a settlement order, this is the allotment order, and this is the permit issued by the competent authority. I have been paying my revenue every year. So once that title has been decided, whether who is in possession or not in possession, my lord, whether that is without deciding on who is presently in possession of the suit, once the title is decided, my lord, in my respectful submission, that may be sufficient to decide the case, merit of the case. That is what I'm making a submission.
Okay, just a minute. Who else?
And more so when eviction orders has been issued.
Just a minute. Okay, like para, whole para, the line counsel for the whole paragraph. The line counsel for the respondent also submits that the stand of the government has been reflected in para 16 of the judgment, wherein it stated that the learned counsel appearing on behalf of the state submits that she would rely on the written gist of argument that has been filed and fairly submits that the settlement order was legally issued and the same was approved by the government, and therefore the plaintiff have the exclusive right, title, and interest over the suit land, and submits that once this should be in the within inverted comma, once the settlement order is issued to the person, he becomes the owner. Inverted comma close. Stop.
And
Just a minute. And in view of the however, the stand of the state has not been contradicted or rebutted by the learned counsel, rebutted by the appellant, respondent in a trial court.
yes,
Stop. Just a minute.
they have not been made a party in the present
Yes.
appeal also.
Moreover, the plaintiff has not met,
Appellant.
the appellant has not met the state as the party respondent in the present
Appeal.
appeal.
Yes.
With regards to the para with regards to the issue number 4, 7, and 8, wherein although the Learned Trial Court has discussed about the issues, but there is no finding have been made. The Learned Counsel for the respondent submits that in view of the Learned Counsel submits that the case of the respondent is covered under the
Order 20, Rule 5.
Order 20, Rule 5. The second part of the Order 20, Rule 5, that is within inverted comma, unless the finding upon any one or more of the issue is sufficient for the decision of the court. Staff. It submits that in view of the finding of the in view of the court, the finding of the court in its final order that my findings are also strengthened, where it stated that within inverted comma, my findings are also strengthened by the fact that on consideration of the material available before this court and the submission of the learned counsels appearing for the parties, that in the absence of concrete evidence, the claim of the Assam rifle that they have been in possession of the said land is valid by their own statement and the record. Inverted comma close. And in view of the fact that the right title and ownership has not been controverted or contradicted by the appellant stroke respondent in the trial court, the possession is treated to have been the possession over the land is treated to have been treated to be with the respondent. Possession over the suit land is treated to be with the it's not necessary to discuss this.
Yes.
Decide. Okay.
Yes.
Possession over the suit land is not necessary or not required to decide, or what you said?
Since, my lord, since in view of paragraph 18, the position is, which your lordship has just referred,
Okay.
in view of the judgment.
And okay.
It is not necessary to give separate
Okay.
finding on the position.
Okay. It is not necessary to give separate findings
On the issue of position.
on the issue of possession. Okay.
Then, lordship,
Mm.
order 14,
Yes.
order 14, I'll only refer about order 14 of the CPC.
Hmm.
Now, lordship,
Order 14.
yes, order 14.
Yes.
My lord, 14.2.
Expand.
My lord, 14 is settlement of issues and determination of suit on issue of law or issues agreed upon. That is the head note.
14.2.
No, 14. 14 deals with settlement of issues and determination of suit on issues of law or on issues agreed upon. Then 14.2, lordship. May I read 14.2?
14.2. Judgment.
Yes.
The court to pronounce judgment.
Yes, court will pronounce judgment on
on
all issues.
Yes. Yes.
Now, lordship, Notwithstanding that a case may be disposed of on a preliminary issue, the court shall, subject to the provisions of sub-rule 2, pronounce judgment on all issues. 2, where issues of both in law and effect arise on the same suit, the court is of the opinion that the case or any part thereof may be disposed of on an issue of law only. It may try that issue first if the issue relates to the jurisdiction of the court. 2, a part of the suit created by any law for the time being enforced.
Where we are?
2P.
Two. Where is?
Court to pronounce judgment in all issues,
Yes.
on all issues.
Hmm?
Lordship said on it.
Yes,
I'm reading. May I read again?
yes, please.
Court to pronounce judgment on all issues. 1,
Hmm.
notwithstanding that a case may be disposed of on a preliminary issue, the court shall, subject to the provisions of sub-rule 2, pronounce a judgment on all issues. 2,
Hmm.
where issues of both law and effect arises on the same issue, and the court is of the opinion that the case or any part thereof may be disposed of on an issue of law only. It may try that issue first if that issue relates to A, jurisdiction of the court, B, a bar to the suit created by any law for the time being in force. Lordship has found it. So, my lord, 2 Roman 2P, a bar to the suit created by any law for the time being in force. Lordship has found that.
Yes.
So, my lord, in the order, paragraph 18, first part,
Yes.
it clearly shows that the res judicata will come into play. Because on the same facts, on the same issue, may I read again?
Yes.
Considering the sufficiency of the learned sufficient of both counsel, I am constrained to note that my decision also is in tune with the findings of Deputy Commissioner Mokokchung in a similar case wherein the present defendants have relied on the same documents as in the present case. It has been affirmed during the course of the hearing that no appeal has been preferred against the said decision of the Deputy Commissioner Mokokchung, and the same has not been disputed by the defendants. No materials have been brought to the notice of this court about any appeal revisions, and therefore it can be safely said that defendants have accepted the said ruling of Deputy Commissioner Mokokchung. So, my lord, res judicata will come into play. The principle of res judicata comes into play, and when res judicata comes into, when issue is discussed on the principle, disposed of on the principle of law, it is not necessary for learned court below to give any findings on the issues, because it's purely question of law.
So he has based his decision on the decision of the Deputy Commissioner.
Yes.
So,
And
in case they file appeal.
it is not filed, my lord, this is
And thereafter if file appeal.
not filed as unpaid because, my lord, this is an order of 2007. This is an order of 25th May 2007. After the judgment also, my lord, this judgment, after the judgment was delivered also, they have not filed any appeal against this. So this has attained finality as of today. So, my lord, principle of res judicata. So, my lord, and because of res judicata, it was not necessary for the learned court below to discuss the
Res judicata will apply if it is a similar nature.
Yes.
If it is the same case,
My lord,
then res
my
judicata
lord,
will
the
apply.
issue is
But
this.
if it is only a
My
similar
lord,
nature,
the issue is,
it may not apply.
my lord, the same plot
The
of
same document, same
My
plot,
lord,
then of course,
the issue is this. The
have to
issue-
satisfy that it is the
There-
same plot,
My lord, the issue is this.
same document.
The issue is this.
Hmm.
Rightly or wrongly, the learned court below has given a finding on this subject matter.
Yes, that is in respect of the Deputy Commissioner premises.
That's, but Lordship, Lordship, may kindly see the grounds of appeal.
Hmm.
On the ground of appeal, in the present case, this is on the ground taken by the appellant that res judicata will not apply, that it is different. It is not similar. That ground is not taken the grounds of appeal here in today's. So when they have not
No,
taken the ground of appeal there
no, the res judicata,
Yes.
when the res judicata applied.
Yes.
on similar issues,
Hmm.
when it is already decided.
Subject matter.
Now, Lordship,
Hmm.
Lordship, can you see the grounds of appeal at page 8? The 11 grounds of appeals given, 9 grounds of, 13 grounds of appeal, whether anything is mentioned by them. So they have accepted that. When there is no grounds of appeal there, we have to go by the pleadings. It's a question of law, but they have not taken as a ground.
No, because whether that case was decided in between the deputy commissioner and the Assam Rifle.
On the same plot of land.
No, how can it be?
My lord, Lordship may kindly see the judgments. These orders are on the same plot of land. It was divided into different places and the grounds taken. If your Lordship, so the other day I have read in detail, so save time,
No,
I'm
you said that
not reading
you
again.
have been allotted. You have been allotted, you have a document, allotment order, isn't it?
Yes,
That document has a plot
yes,
description, has
yes,
separate description of your
My
own
lord-
plot.
yes.
You know, some side or some portion would be bordering
My
with
lord-
the deputy commissioner office, I think
My
probably.
lord, the issue is this.
Hmm.
The issue, what the learned court found, what the finding of the learned court below was,
Hmm.
the land, the same ground of defense,
Hmm.
exactly the same ground of defense was taken in the present case and the deputy commissioner's building in the lower court, in the court below.
Maybe, but then not the same plot.
No,
Hmm.
same area, I'm saying, same area,
Hmm.
not same plot. It can't be, it is a
Yes,
simple
that is-
conventional, same plot cannot be
Yes.
given to 2 person,
Yes.
but in the same area.
Hmm.
Same area and the same ground of defense. Lordship, same documents are relied upon, same documents, but that is what the learned court below, paragraph 18, first part says. It says, similar case wherein the present defendant is relied on the same documents as in the present case.
Same document,
Yes, same documents. Same documents,
same rough sketch map.
same documents. It's a same rough sketch made, same documents, everything same. That is the issue.
Hmm.
So, my lord, I leave it to your lordship, but then my respectful submission. And also, in no way the appellants are aggrieved by this portion of the order in the grounds of appeal, no, it is challenged.
Mhm.
It is attorney's finality. So, my lord, res judicata and on the preliminary issue also, that is also an issue for lordship.
Let us just see, let us see section 11, res judicata.
Yes,
Just
lordship,
read
yes, fine.
read the content once, just.
Res judicata, lordship, paragraph.
Just a minute. Yes, section. No, just a minute. Huh? Yes, please.
No court
Hmm.
shall try any suit or issues in which the matter directly or substantially in issue has been directly and substantially in issue in the former suit between the same parties or within parties under whom T R or any of them claim litigating under the same title or in a court competent to try such subsequent suit or a suit in which such issues has been subsequently raised and has been heard and finally decided by such court.
See, directly and substantially
My lord,
in issue in the
My
former
lord,
suit between the same party.
my lord,
Hmm.
my lord, I am covering on the word substantially,
Hmm.
substantially, because same documents.
Between the parties and whom?
Because, my lord, parties are same. Because the state also were respondents in the lower court below. Lordship, I have shown in the plain. So state was a party, deputy commissioner was also a party, lordship mechanically see.
The plaintiff was different.
Lordship mechanically see at page 34, parties were same. Yes. Well, lordship mechanically see the state, who are the respondents in the original suit.
But you were not there.
My lord, but the res judicata applies to the other parties. My lord, the state of, see, this, lordship mechanically.
It is not between the same.
Lordship, the same party, lordship is the state of Nagaland, respondent number 3. The state of Nagaland through the secretary land revenue deputy.
No, that is there. But
Then 4, deputy commissioner Mokokchung.
where is your name?
My name is not there, but the deputy commissioner was there.
So how that can be the same party?
Same party deputy commissioner,
No.
and
Then-
it is a submission, my lord.
Yes, that way it can.
It is the submission of the learned appellate court now.
Is it proper to count that one? Because the state, in all the cases against the state, will, of course, they'll make
Well, no.
party to the state. So we can't
My
count
lord, the
that.
point is,
Hmm.
this case
Hmm.
was a decision, is a dispute between the deputy commissioner Mokokchung and the Assam Rifles.
Correct.
This case also,
Hmm.
if your lordship may kindly see, this is a case between the this is a case where the deputy commissioner was also a party.
Yes, deputy commissioner was definitely, of course, party, but then you were not there.
I was not there. There's no dispute, no dispute.
Then
That's
how-
why I'm saying,
Hmm.
that's why I'm saying substantially. It is substantially covered since deputy commissioner was a party. I'm not claiming the first part. I wasn't a part, I was not a
whether in
member.
the decision of the deputy commissioner, whether the deputy commissioner has made the description of the lane
Lordship, yes, lordship, it is
Okay.
there.
in anywhere your lane covered,
My lord, the
in
issue,
anywhere, any
the-
side.
the only issue I'm making, my
Hmm.
lord, the only issue I'm making a
Probably.
submission. The only issue I'm making a submission and
Hmm.
what the learned court has found
Hmm.
is that we filed the petition and the crown of defense taken by them is exactly the same like the grounds taken in this case.
Maybe.
And lordship, and what that has been decided against them by this court, competent court, and they have accepted that land was given to them. So whether the same grounds which was rejected by a competent court and they have acted upon, whether they can use the same defense in the subsequent case which has been found to be, my lord, illegal. That is why, from that point of view, I'm making a submission. The rest I leave it to your lordship. Because, my lord, I filed a case, somebody take a defense. And that ground of defense was rejected by this honorable court. Then tomorrow another person come, file a case against them. And the same ground is taken. Then what this court will say? Whether this
No,
court will
because
take an
if it is not
independent
the-
decision?
If it is not the same plot, they may not like to contest with the other one.
My
They may
lord-
like to
My
contest
lord,
with
the
the
point,
one.
the question is same different plot. But the crown of defense, because the crown of defense taken is that
Maybe.
they have been in continuous position. Then the Mukchung settlers has written a book where the map is given, and then the children's survey was conducted. These are the three grounds.
Here is a case where the Assam Rifles had a building existing in this plot.
No, my lord.
Hmm.
Not in a portion,
And whether the same.
in a portion,
Hmm.
in a portion of the suit land, there's a dilapidated building, that's all.
Hmm.
Not the whole plot.
Hmm.
In a portion,
Hmm.
there is a old dilapidated building, that's all. That is what the order says. Not the whole building, not the whole plot.
Okay.
Now, my lord, I'm giving a judgment on
Yes.
the power of first appeal. Because, my lord,
Yes.
2018, 1 SCC 604.
Earlier given.
Today only, lordship, that the judgment is coming up.
Is the earlier referred one? Okay.
My lord, what is the scope and power of first appeal under section 96 CPC? That is what I want to remind you, press your lordship.
Yes.
My lord, I'm reading from 11,
Para.
para 11. It is a settled principle of law that a right to file first appeal against the decree under section 96 of the code is a valuable right to the litigant. The jurisdiction of the first appellate court, well, hearing the first appeal is very wide, like that of the trial court and it is open to the appellant to attack all findings of the fact or end of law in the first appeal.
Yes.
It is the duty of the first appellate court to appreciate the entire evidence and arrive at its own independent conclusion for reasons assigned either of affirmative or defense.
It is a continuation of suit, yes.
Yes. Similarly, the powers of the first appellate court while deciding the first appeal are indeed well defined by various judicial pronouncements of this court, and therefore no more res integra, that is entirely new. It is opposite to take note of the law on the issue. Then, as far back as 1969, the learned judge Ayer, while deciding the first appeal in section 96 in such and such, reminded that the first appeal court of its duty to decide the first appeal in his distinctive style of writing, which I'm reading the quote. The plaintiff, unsuccessful in 2 years, has come up here aggrieved by the dismissal of his suit, which was won out for declaration of title and recovery of possession. The defendant disputed the plaintiff's title to the property, as also his possession and claim put in himself. The learned Munsif who tried the suit recorded findings against the plaintiff put on title and possession, but in appeal, the learned subordinate judge disposed of the whole matter clearly and briefly in a few sentences. Quote, an appellate court is the final court of fact ordinarily, and therefore a litigant is entitled to a full and fair and independent consideration of the evidence at the appellate stage. Anything less than this is unjust to him. There is no doubt that in the present case, the learned subordinate judge has fallen far short of what is expected of him as an appellate court. I'm reading 14. This court is also in various cases reiterated the aforesaid principle as laid out the powers of the appellate court under 96 of the court while deciding the first appeal. We consider it opposite to refer to some of the decisions. I'm reading the quote. The appellate court has jurisdiction to reverse or affirm the findings of the trial court. First appeal is a valuable right of the parties, and unless restricted by law, the whole case is there and open for rehearing, both on question of fact and law. My lord, this is important.
Yes.
Open for rehearing. The judgment of the appellate court must therefore reflect its conscious application of mind and record findings supported by reasons and all the issues arising along with the contentions put forth and pressed by the parties for decision of the appellate court. While reversing a finding of fact, the appellate court must come into close quarters with the reasoning assigned by the trial court and then assign its own reason for arriving at a different finding. This would justify the court hearing in further appeal that the first appellate court has discharged the expected duty of it. The above view was followed by the three-bench decision in such and such, where it was reiterated that sitting as a court of first appeal, it is the duty of the High Court to deal with all the issues and the evidence laid by the parties before recording its findings. In such and such, the first appeal has to be decided on facts as well as in law. It is in the first appeal, parties have the right to be heard both on question of law as also on facts, and first appellate court is required to address itself to all issues and decide the case by giving reasons. Unfortunately, the High Court in the present case has not recorded any finding either on facts or on law sitting. As the first appellate court, it was the duty of the High Court to deal with all the issues and evidence led by the parties before recording the findings regarding title. Again, in such and such, well, considering the scope of section 96, this court observed as follows. A court of first appeal can reappreciate the entire evidence and come to a different conclusion. Again, in such and such, this court, taking note of all the earlier judgments of this court, reiterated the aforementioned principle with these words. How the recurrent first appeal is disposed of by the appellate court, high courts have been considered by this court in various decisions. Section 41 CPC deals with appeal from original decrees. Among the various rules, Rule 31 mandates the judgment of the appellate court shall state the points for determination, the decision thereon, the reason for the decision, where the degree appealed from is reversed or varied, the relief to which the appellant is entitled. That much, Lord. I'm making a submission, my lord,
Yes.
that this honorable court has full power to re-examine,
It
reappreciate.
is a continuation of the trial.
Yes,
suit.
yes. So my respectful submission, I mean that the board must under judgment, your lordship is well first. So my respectful submission is, lordship, under technical issues of whether there's a finding on certain issues or not. My lord, since this it's a continuation, as your lordship is really rightly pointed out, it is a continuation of the trial court. So, my lord, my respectful submission is, it is for the interest of both the parties. Because, my lord, that if this case, my lord, if this honorable court in the exercise of power under 96 can reappreciate and re-examine all the issues, all the issues framed, and take a final call here instead of further delaying the matter. That is what I'm making a submission, because it is for the interest of both the parties. It is for the interest of both the parties. On the issue of position, he did not give certain findings. Admittedly.
Since that issue was not discussed, even certain issues.
But, my lord, issues were discussed, but he did not give finding on those issues.
Yes.
Unfortunately, the error committed with due fairness.
Yes.
Is that the learned court below discussed the issue in detail, but failed to attend one line on the bottom on the two paragraphs. That is
Issue number 4 also discussed? Probably 4 not discussed.
for discuss.
Okay,
Both the issues were discussed, but there is no finding given.
right.
Otherwise, the issue submissions of both the parties is recorded in detail in both. That is issue number, lordship, subject, kindly remind me. Say issue number, my lord, issue number 8 and issue number, issue number 4, issue number 7 and 8. Issue number 4, issue number 7 and 8, he discussed in detail, but unfortunately, he did not give a finding on the bottom. But issue submissions, everything recorded, lordship, you can read. See, in issue number 4 also, detailed submissions were recorded. Then, my lord, issue number 7 and 8, paragraph 13, also it is recorded. Then he did not give a finding. But my respectful submission, since it is a continuation of the trial court, this honorable court has the power to re-examine everything, re-examine and reappreciate everything in past
Take one paragraph.
appropriate orders.
The
It will not prejudice anyone.
Counsel for the appellant, respondent for the submits. The learned counsel for the respondent submits. That. Fairly submits that although the issue number 4, 7 and 8 is elaborately discussed in the judgment of the trial court. However, but the findings have not been given to the said issue. However, findings have not been given. No findings have been given to the said issues by the trial court. However, since the appellate court is a continuation of the suit, this court has an ample power to discuss and also to discuss and to decide on findings. Okay.
It will not prejudice both the parties.
Okay.
It shall not prejudice.
Without any prejudice to the other opposite party. Okay. Without any prejudice to the opposite party. Okay.
Well,
So we'll continue to.
much of it, yes.
Okay.
May it please, Lord.
Yes.
My lord.
Probably others. If any other matters, we may
Yes.
have to adjourn because we
My
are
lord,
going to
yes.
continue with that.
Supplementary
Yes.
item number
Just a
38
minute.
and 39.
Just a minute.
my lord.
Supplementary item
Item 38, 39.
38, 39.
Yes.
Okay.
My lord, if this matter can be taken up on Friday. 31st, yeah, Friday,
It's Friday.
31st May. It is a part out matter, my lord.
Part her.
Yes.
This Friday.
Or if not on Monday, coming Monday,
Okay, Monday, we'll take up on Monday, okay,
third June, my lord.
okay,
I'm for the respondent, my lord.
okay, you are Miss,
Affordable.
Miss
Mapinig.
Land Council for the appellant, and Mr. Lukham and K. Lukham, Land Council for the respondent are present on the, yes, on the agreement of the party, list this matter again on Monday. Okay,
It's part of my lord.
as part heart.
Most.
I think in the order it is reflected as a part heart
Yes,
only.
yes,
Okay,
yes, yes.
yes,
Mr. Lordship,
yes,
beg for your indulgence in item number 28, your lordship.
28.
Your lordship, I've just been informed that the council for respondent number 5 will be taking some time today, but he's not present here today, lordship.
Okay. Item 28. Oh. Okay. Miss
Biketsono for the petitioner.
Land Council for the petitioner is, you're for petitioner
Petitioner,
is present.
council number 5. He's absent today, he's
Okay.
not present.
Mr. Oh, you are for the state here.
No, your lordship.
Okay, okay. However, the Land Council for the respondent number 5 is, okay. You have a consent with him.
Lordship,
He is absent, okay.
he's absent, your lordship.
Okay. He is absent. And Land Council for the respondent number 5 is not present in the court today in absence of. This is on in
I-
order column
No, lordship,
Hearing,
hearing,
okay.
hearing.
in absence of the Land Council for the respondent. This matter staying adjourned. List this matter
3 weeks, your lordship.
after 3 weeks. Okay. 28.
Pleasure.
Mayor, please, my
Yes.
Your Lordship, we have item number 36.
36.
Yes, but since our matter could not be reached today, Your
Yes,
Lordship,
Probably
another
it
date
will not- it will
may
not reach.
kindly be
Lordship.
given to us, my Lord.
Okay,
Longer date may be given, Lordship.
Okay.
July first week,
Mr. You are Mr.
Mr. S. A. Sheikh, Lordship.
Land Council for the, okay, SS Sheikh, Land Council for the petitioner is present. Also, Mr. Angami, Land Council for the state respondent. Stop, is prayed for by both the Land Council for the party. List this matter
Can it be fixed first week of July, Lordship?
during the first week of July. Okay.
I'm deeply obliged, my Lord.
Awesome.
I think so. Okay. Resume.
We have come for only for this one of this.
The presiding officer was interested in. It was a PC template, PCS design. And then now I just manage the profession. It is located in a suitable area. Therefore, the district report of convenience. Therefore, the district should find a suitable place. There. No, that means no absolute. Whereas judicial council is between the same parties. And even the global people, not same party. Same party. Trying to make a break between same party. No.
See you in first week of July. We see your passport. Yes, yes. I think my voice is already. But
Yes,
Lordship, I'll just make a small factual clear reminder, then I'll conclude. Lordship, paragraph, page 18, the page 48, I'm sorry, page 48,
yes.
the residential permit. Page 48,
8,
yes.
yes, para 14.
No, page 48, page 48.
Yes,
Lordship is found page 48, not paragraph.
page 48, paragraph.
No, my lord, this one.
Okay, oh, this is 48, 40, just a minute, huh? Last one page, which is not necessary, should actually.
Yes, this is the paper book, so I'm also equally confused, Lordship.
48.
Yes, only clarification.
Yes.
It was clarified.
Copies of the mock-up.
Yes, it was clarified to Lordship on the last occasion also, but I'm trying to remind you, Lordship, again.
Yes.
Permit number 2045 dated 29/3/79 is the original allotment permit number, though else sub in the year 79. Because in the revenue department, to ensure that the file is not lost, the original record is maintained. On the top, Lordship, transferred white dated 16 May 2005 is written.
Yes.
So the other day also, your Lordship has saw the clarification on this, and it was clarified to you, Lordship, the other day also, so that there will be no confusion there. Because an issue was raised that how the permit was issued on 79 when the seal deed was issued thereafter. That was so. Just to clarify that portion, and in fact, through the pleadings also, it was clarified to you, the Lordship, the other day. Now, in
So
conclusion,
pleading in which para?
Lordship, let my junior find out, and I'll give you.
Okay.
I
So just list of that, if it is possible, then list of that. No?
Okay.
List of that, if possible,
We can,
would help because it's a long one.
yes, we can
You have a
give,
long date also.
we can give,
List of that.
we can give.
Can you give a list of that? And these also reflect. Just
So
brief, small brief.
we'll give,
No need of all the entire argument, but then small brief, whatever. If you
we'll give,
yes,
we'll
that
give,
will help.
we'll give.
Right.
Because then in conclusion, I'm
Yes.
concluding, Lordship.
Hmm.
Now, my lord,
Hmm.
a very pertinent question is this.
Yes.
Under what title, under what basis the present appellants are claiming ownership and possession?
Hmm.
That is the core issue.
Yes. Hmm.
My submission is that I was allotted a plot of land. My cousin was allotted a plot of land by the government. Settlement allotment order, then settlement order was issued. The deputy commissioner issued me permit, and the municipal council.
And you were given by your
Then I bought it
by way of you were
gifted.
Hmm?
By way of gifted, as well as I bought it from the original landowners also.
Did that, no? So
Yes.
all those.
I
yes.
bought it. I bought it from the original landowners, also traditional owners, as well as gifted from my cousin.
Okay. So apart from gift deed, that is being allotted by the government, you have to purchase from the original land.
Original
Also, that
any discrepancy because unfortunately
that
in
document is
Nagaland.
also there.
Yes, still it is all. Unfortunately, in Nagaland is even if permit is issued by the government, the traditional
You have
owners
to
will
purchase
keep on.
from the traditional owner.
Yeah, traditional owner will continue to disturb.
Okay.
So avoid disturbance.
Ah.
I mean, local issues.
Okay.
So that is why. Those dates I'll give within by Monday.
Right.
By Monday we'll give.
Right.
My juniors will prepare there.
Okay.
I will indicate that one also
Yes.
for a particular paragraph.
Okay.
Now the issue is this. Under what basis?
Hmm.
They are claiming ownership in possession.
Hmm.
That is the coercion. Now, my lord, going to the affidavit, plain and written statements, read the bill, on 4 grounds they are claiming. One, they are claiming that compensation was paid way back in the British time. That 100 rupees was sanctioned by the government of Assam, and accordingly, with that, they bought this plot of land. In the TCL, Malo TCL is a plot of, is a big area, and their occupation of a large area, and the present dispute is only a portion, a plot of land of the in the TCL which is under their possession. So it has to be treated as one. Now their claim is that the land in DC Hill, we paid compensation.
DC, what?
DC Hills.
DC Hills.
Mogokchum, yes.
Hmm.
We'll keep the record.
So out of these DC Hills, and probably what they are claiming that they have purchased by paying 100, and probably apart from DC, you and others, I think so many peoples are under occupation. in these hills.
Yes. So they are claiming that a portion of that, portion of DC Hill, it is compensated. That is the first claim.
Hmm.
Unfortunately, you were not able to show any record in evidence, any documents, how it was compensated. Nothing is mentioned except for a statement. No documents, evidence to prove that the landowners were compensated. One.
There were some documents also showing. No,
I'm coming.
okay,
That's why I'm saying 4 grounds.
right.
So first one, they are claiming that they paid compensation.
Hmm.
Secondly, they are claiming that they are in continuous occupation since 1885. Since that is their second claim.
Hmm.
So they even indicating that adverse position will come into play. That is the second claim. Third claim, they are claiming that
It is in the ground, given in their ground for claim,
no, Lordship.
not in the ground.
Lordship, we have gone to the ground repeatedly, so I'm not going.
Okay,
But this is what I can infer.
okay. Number one is?
Number one, compensated.
Hmm. Hmm.
Second, continuous occupation positions in 1885. 1889. Thirdly, that a joint survey was conducted between the district administration and Assam Rifles sometime in 2014. And
Joint survey conveyed. Huh?
a joint survey of the district administration and Assam Rifles were conducted sometime in the year 2014, and that joint survey shows that this present plot is under occupation of the Assam Rifle. That is their claim.
Hmm.
Fourth ground is on the 100 years liberation of the establishment of Mogokchung town, the town's settlers has published a souvenir, and there they includes a map where it shows that Assam Rifle is in occupation of this particular plot. These are the 4 grounds on which they are claiming ownership in possession, Lordship. Now, Lordship, subject to repetition.
Yes.
If somebody is claiming that it is compensated, they should bring some record and evidence. Some documents should be there. They have miserably failed to produce. One. Secondly, Lordship, subject to repetition again, I have also enclosed a judgment of the Honorable Supreme Court that the adverse position doesn't apply to government and its agencies.
Right.
Thirdly, Lordship, the so-called joint survey of 2014, it was never approved by the state government. Joint survey may be conducted, may be prepared, but it should be approved by the state government. That was never done. In my case, my lord, the joint survey was approved by the state government. That is what the record says. The issues also has decided that particular issue already decided. And fourthly, Lordship, whether on the basis of a souvenir book of an NGO, you can claim the title of ownership.
That will not be the authentic one.
Yes. If that is so, my lord, some association can prepare, publish a book and claim whole Kohima as mine.
Yes.
So these are the four grounds on which you are claiming ownership in possession.
Hmm.
Now, my lord, the same four grounds
Hmm.
was the sole defense in the 2007 case with regard to dispute over Deputy Commissioner's office, plot of land for the Deputy Commissioner's office, because TC here, lordship, is considered as one. The occupation of the house rifle and TC Health is considered as one, because this portion is a portion of that. And rightly or wrongly, lordship, the learned Deputy Commissioner in the order of the 2007 has rejected all these four grounds. And he had accepted the same, no appeal, no revision, nothing. So, my lord, the claim of ownership in possession on the basis of these four grounds is already dismissed by the Deputy Commissioner as early as 2007. Then that is the reason why the learned court, trial court below, has upheld that it is covered by the order of the Deputy Commissioner of 2007, because the title is gone. The title on which, the four grounds on which you were claiming ownership in possession is already dismissed by Deputy Commissioner in 2007. That is why the learned Deputy Commissioner, the learned trial court says, since no appeal revision has been filed and the grounds taken here is identical, ground for claim of ownership in possession is identical, it is covered by the earlier judgment of order of 2007 of the Deputy Commissioner, since it has attained its finality. That is the reason why, my lord, we are submitting that the present case is substantially covered by the principle of res judicata. And unfortunately, lordship, the Deputy Commissioner who was a respondent in the trial court has not been made a respondent here. In other words, they have accepted the stand of the government because no grievance against the state government and the Deputy Commissioner. Land Revenue Department was a respondent, Deputy Commissioner was respondent, they were not made respondents in the appeal. So no grievance against the state government, and it is the state government who has allotted the plot of land to me, and they are a party here, so they have accepted and never challenged. So that is why, my lord, my respectful submission, the principle of res judicata has to be appreciated from that perspective. Much obliged, lordship.
Okay, just a minute. Wait. Okay, okay, you carry on then.
Yes. May I please, your lordship?
Hmm.
Lordship, I'll take only 5 minutes in that.
Yes, yes.
Since my most respected senior advocate has also highlighted all the facts of the matter,
Yes.
along with the order in continuation with the previous deed.
Right.
So I'll confine myself only to a few pertinent issues, two, three issues, since we know to save time. Firstly, lordship, it is we have discussed in other senior advocate has also banking on so much on the 11 issues which has been filed at the time of the learned court below. That is
Yes.
11 issues. It is very clear that I will not emphasize more on that none of the issues were decided. Now, as for Order 21, CEO of the CBC, lordship, my senior advocate has also read out the provision also. Lordship, I'm sorry, Order 20.
Order 20.
Order 20, Rule 5.
Yes.
Here, regarding those issues, how it should be decided, how it should be discussed and decided.
Yes.
Here, it is applicable in this case. Now, I'll maybe have to read out the
Order 20 rule?
5.
Rule 5, yes.
Rule 5. Court to state its decision on each issue. Each suit in which issues have been framed, the court shall state its finding or decision with the reason thereof upon such separate issues upon each separate issues, unless the findings upon any one or more of the issues is sufficient for decision of the suit. Lordship, interestingly, we have to read this the total provision in totality, not only those provisions which are convenient to a particular party. Now, my learned responding counsel is emphasizing only on those provisions in the second part, which I mean, unless the findings upon
Yes.
any of such.
Yes.
But if we have to read in totality, the concerned court to frame the issue have to discuss and decide on each and every issue. That is the provision under Order 20 rule. Lordship, Section 11 of the CPC that is reached together. It is very clear that the Lordship has also expressed that where it is applied. It is applied only to in respect of the suit land or subject matter of the issue is the same between the same parties. Now, those issues, Lordship, since we have discussed, I'll just read out those provisions. Lordship, in page number 26 of the paper approved, which is issue discussing on issue number 2, 3, and 5 in the judgment, the impugned judgment.
Yes.
Here, it is very clear that my learned counsel for the respondent has also read out that the provision which was convened to. It have to read out the last part.
Last
But
part, whereas, yes,
whereas,
regard,
whereas as regard to the Lordship,
residence.
residential permit number 2045 issued by the town committee in Mokuchung, it is difficult to understand as to how the transfer of the residential permit number such and such was issued in the name of the plaintiff by the municipal council Mokuchung, dated 29/3/1979, executed P7 of the plaintiff. When the Deputy Commissioner TCS only on 16/5/2015 issued a transfer order on the request of the written by Sri L. Susang Jame in 2015. There is a huge contradiction in that. Now the court is of the opinion that although it was not decided, I have not made any decision on this. The court is confused. The court is not clear, Lordship. There's a big question mark. Now the entire issues which is discussed in that entire, these are only the extract of the submissions made by the parties in their respective pleadings. Now, as per Order 20, it has to be
Here,
Lordship.
what the learning counsel for the respondent submit is that this came out in the above, it is marked, there is a remark,
Lordship.
transferred by DC order number so and so. Ne? So here
Yes.
79 only mention that transfer by DC order number. So this is what he's they're trying to justify.
Lordship. Lordship, if you turn with me at page number 70, that is the residential permit which was issued by the municipal council, which is referred in this issue in page number 70, Lordship. Now
70.
770, Lordship, 70. On the right side, there's 2 pages which is so rather confused, but on the right corner,
Yes.
that is page number. This is the residential where permit number also very clearly mentioned 2045, Lordship.
Yes.
And the date of issue is 29/3/1979. Lordship, the list of dates, what the Lordship has rightly mentioned, it is very clear that here the basis of the claim of the respondent is on this. By this allotment, the respondent is claiming that she has got a legal right over the suit land. This is the basis of her claim. Now in 2014, another the gift deed, which was in 2015.
What is your submission here in this page number 70?
Page number 17. Lordship, here in 1979, this residential permit has been issued in the name of Appellate. Whereas the name Appellate, the respondent came into picture only after 2014 when she has purchased the plot of land, which they have an sale agreement. Now, after the purchase was made in 2015, Lordship, the land was transferred or gifted from L. Susang Jamil. Whereas in that allotment order, it was not Appellate. Now there's a clear sign of manipulation, which has not been.
When is the allotment order? Yes.
Lordship in 1978.
78.
1978.
Okay. But
And it was
whether
approved-
29/3/79 has been
Lordship,
find mention in anywhere?
Lordship,
Any
can you
day?
see paragraph 30, page 36, paragraph 4 of the plain? Sorry, my lord, I am intervening, but just to show the report.
Para,
Paragraph 4 of the plain, page 36, page 44.
page 44.
Yeah,
No, page 44.
page 44 in with all letters, written page 36 also, 44 also. The plain.
Okay.
Original plain. My plain is at page 42. In middle,
44, para,
paragraph 4.
4.
Yes. Lordship,
Then there are,
may I read?
yes.
There
yes,
are
please.
Deputy Commissioner Mawjung Nagaland, defendant number ordered by order dated 18/10/78 made a settlement at the said land in question in the name of El Susang Jamir with condition inter alia. Further, Deputy Commissioner Mawjung clearly commended the settlement order shall not transfer the land by sale of mortgage or lease to another person without permission of the Deputy Commissioner. Thereafter, El Susang Jamir was permitted to hold a residential permit number 2045 in the name issued from the Office of the Municipal Council Mawjung Nagaland dated 29/3/1979. This is what I was claiming.
In this name issued from the office of the municipal, on whose name El Susang Jamir.
Yes, the original authority. Then it was subsequently transferred thereafter. That is what I am submitting.
Okay, just a minute, just a minute. In the council for the respondent submits that, the residential permit was issued in the name of the present respondent Abenla Imsong.
Imkong.
Imnong, no? Imkong. On which date it was?
Password 16/5/2015.
16/5/2015, based on
Permit number
Permit
2045. Dated
45
29/3/79.
issued.
Originally issued to Mr.
Originally issued to
Sri El Susang Jamir.
Sri El Susang.
Original allotee.
Sri El Susang Jamir, original LOT. That is what he is submitting. Because above were, of course, in both the documents, in the earlier documents also, page number 48 also there is this, I think probably earlier also they have annexed. And in this 70 also.
Same,
So
same.
this,
Yes,
yes,
this is
same
same
copy, and above it is mentioned, and that is what he is justifying.
Lordship.
The counsel for the respondent justify that this is reference only.
Yes.
What they are saying. So this is that is why I also raised the same question.
Lordship.
I raised the same question, how it can be.
And this is part of my plain, Lordship. This is a statement in my plain, the paragraph 4.
Okay, so just a minute.
Yes, Lordship.
Yes, please carry on.
Yes, Lordship. So regarding that mention of now, Lordship, you may appreciate that Mokchun town, it was is on heading that municipal town council, which was my learned respondent council is saying that it was allotted only after 2015, which is referring back to 1979. In 2015, it was municipal, not a town committee, it's a municipal council.
Mokokchung
Municipal
Municipal
Council.
2015, not a?
15, because the it was made
Okay,
in 2015.
okay.
Lordship,
Then so this will be the submission of the respondent with the appellant. Appellant. Okay. So when I dictate separately, this is for the appellant only. Earlier was it the respondent, Okay. Now, his submission is done. The learning counsel for the appellant submits that. Your submission is that
The transfer of the suit land
the transfer of the suit land from
the
Original-
allotee
LOT, original LOT El Sesong Zamir to
the respondent.
to the respondent Abenla. No, not the respondent. Yes, respondent Abenla Imkong only was done
On 16/5/2015.
on 16/5/2015
By an order, Deputy Commissioner order dated
by an order of the Deputy Commissioner.
16 May 2015.
Okay, that is 16 May, okay, 2015.
Okay.
However, the residential permit shows that the residential permit issued under the signature of Mokokchung
Mokokchung
Municipal
Municipal
Council was made, sorry. However, the residential permit was issued by the Mokokchung Municipal Council only on 29th. Sorry,
29/3/79.
hmm?
That was the
Okay,
municipal
shown
council.
residential permit issued by the Mokokchung Municipal Council has been shown on residential permit number 2045 to the Abenla Imkong on 29/3/79, which is prior to the issuance of prior to the transfer of the said property by way of gift deeds in the year 2016
15, 1 5.
or 15.
Yes.
15. Okay, so your submission is that during this period, Mokokchung municipal was not there.
2015 municipal council, municipality, it was town committee.
Okay.
It was
Further, in the year 2015, the authority who issued
designated as municipality.
only municipal.
It was there already. 2015, from 2003 also municipal council has come. Contested
Okay.
also.
You have any document? to show?
Yes.
That is the general
From
municipality.
Just a minute. You have any document to show that?
Municipal council.
Uh,
That is not a fact.
No,
Three district has been declared as municipality. That is Kohima, Dimapur, and Mokokchung. Now, prior to that, it was town council.
Town council.
Town council.
So you have any document?
That is the Nagal Municipal Act 2001 from there.
Yes, 2001.
2001.
2001.
2015. Act was passed in 2001. First municipal election was held in 2004 in Nagaland Lordship.
So the authority,
Yes.
otherwise it's fine only. The authority.
Act was
Okay,
passed in
okay,
2001.
Okay, then fine. Yes.
Lordship referring to the area, the size of the. Now, Lordship may appreciate that Order 7, Rule 3 is very specific in respect of a landed property, immovable property.
Order
Where
7?
the discretion. Order 7,
Ah.
Rule 3 of the CPC Lordship.
Order 7, rule
Rule 3.
3.
Lordship, I mean.
Yes.
Lordship.
Order 7,
Rule
rule 3.
Where the subject matter of the suit is
Subject matter of
immovable
suit.
property.
Fine.
Now, where the subject matter of the suit is immovable property, the plan shall contain the description of the property sufficient to identify it. And in case such property can be identified by boundaries or numbers in a record of settlement or survey, the plan shall specify such boundaries or number. Lordship, it is very clear that it is the plaintiff should come up with a proper description of the suit land. Now, as per this allotment, which was for a moment that if you accepted the allotment in 1979, the area is mentioned as 110/73 into 100/65. In other words, 105 into 69. It should be divided.
Okay.
Four sides.
Okay, the land council for the appellant further submits that as
So the original
per the order 7, rule 3, where the subject matter of the suit is immovable property, the plan shall contain a description of the property sufficient to identify it, and, in case such property can be identified by boundaries or numbers in a record of settlement or survey, comma, the plan shall specify such boundaries or numbers. Stop. However, in the instant case, the same has not been mentioned. The allotment order, what is called this allotment order?
Yes, original allotment order.
Okay,
The original allotment order.
the original allotment order issued to the original allotment order issued in the name of what is his name?
L. Susang Jamil.
Hmm?
L. Susang Jamil.
L.
Hmm,
Susang.
Susang Jamir only mention the length and breadth.
Yes, the total area or
What
land
the,
and
the
breadth
total area
of the suit land,
of a suit
or
land,
rather allotted. portion.
total area of a suit land. You have just read out length. How much meter that one?
This 110 into 73.
110 into
73, 73.
73,
Yes, 100 into 65.
100 into 65.
Now this is mentioned, clearly mentioned in the allotment order. Now, my learned senior.
Page 69, it is there. He's misleading. This
Huh?
question is there.
69.
Yes, page 69. My lord,
Just a minute.
the clear,
Just a minute. Just a minute.
Yes.
it is there. In the land settlement order, he has only read the first page, the second page.
Lordship, I'm coming to the point why I'm referring to this one.
This
It's not that I'm disputing the record. Now, in 2015, Lordship, the respondent is repeatedly emphasizing more on relying on the survey map, survey which was conducted in respect of the suit land, which was headed by Land Records and Survey Mohotung. Now, Lordship will tell you that page number, from page number 77 in the
So
in the-
here in
in
this
the paper book.
point, can your submission also will be recorded
Yes,
here
yes.
in this case?
I'll-
So let
I'll-
me
I'll-
record
I'll-
this.
I'll-
Lordship, I'll make it very
70,
precise
70?
from 77, Lord.
77.
This is the submission of survey report dated 4th May 2015 from the Office of the Land Records and Survey Office.
Submission of survey report.
Yes, Lord.
Yes.
Now, this is a covering letter. And page number 79, come to 7. This is specifically referring, and the sketch map is for the suit land, where the respondent is claiming. Lordship, there is a differences of opinion. Why I'm referring to Order 7, Rule 3. The plaintiff or the respondent is not in the position to come up with a clear demarcations or the all of those.
Okay.
Because this is very clear.
Moreover, there is
Yes.
a difference. So, moreover, the measurement mentioned, sorry, the description, just a minute. The description of the boundaries and the measurement mentioned in the land settlement order dated settlement original is 8/10/78.
Original is 15 July 1978. That is original allotment,
15 July
1978.
1978.
And the survey,
79
1978 is
or 78,
is the
78.
original allotment.
78 and the survey of and the survey report. This is
Yes,
survey report.
Survey report in respect of the respondent's land.
So where is that is annexer.
And
That original allotment is annexer.
annexer 13.
Annexer 13 within bracket annexer 13 and the
Annexer
survey
13 of the
report.
plan.
Survey report
Yes.
submitted by
The land record and survey
the
office.
land record and survey office
No, office.
officer dated 4/5/2015
4/5/2015.
and the sketch map does not tally with each other.
Yes.
No?
Yes,
Oh.
that was separate. And Lordship,
Map,
yes.
tally with each other. Okay.
Now, there is a 3 records, a contradictory record. Now the allotment, as per the original allotment 1978, July 15, 1978, where the area has been specifically mentioned in the survey report. That is the latest survey.
Father, there is a 3 contradictory.
No,
3
then-
contradictory
The area,
area.
the record which shows the differences of the suit land, area of the suit land.
Father, Samidat, there is 3 three contradictory record regarding the area of the suit land.
Suit land.
That is, which are the
Now,
three?
this is the original allotment, which is at page number 70, that is 15 July 1978.
That is in the original allotment issued on
15 July.
15
July 1978. That is page number
16 7 1960
78, 1978.
and 1978
Lord.
annexer.
This is annexure 13 in the plate file.
No.
This is
This is settlement order.
this is the first settlement order, and page number 69 is the approval, common approval order dated. That is in October.
No, which
Page number
document you are talking about?
68. Page number
68.
68. Yes, Lord.
Annexer 13.
13.
These and which one? Number 2.
Number 2 is the survey report.
The survey report dated.
Survey
Survey report dated 4/5/2015
and just in the decree. In the decree also it's not tallied. What in the decree? In the impugned judgment in order. The decree
and in the impute and
Yes.
in the
impugned
decree and decree in the impugned judgment and order dated
29
29
9 2018.
9/2015.
18. Lordship, to make it to cut it short, there are three where unless the assertant, the plaintiff assertant, or satisfy the court with the suit land, this much is the area. How can the court pass a judgment like pass a decree over on the area? But there is three different records shows that is a differences in the area. Now
There is no clear.
clear of the size of the suit land.
Okay.
As named by the
Unless there is a clear, unless there is a clear
everything, yes.
size of the area of the suit land, it cannot be decided.
It cannot be decided because it will, it
The
will
same
not
cannot,
be
the same cannot be decided.
No, because the lordship, the respondent is claiming that it was basically the claim was based on the allotment,
Okay.
which was in Webber 979.
As the respondent, as the claim of the respondent is based solely on the allotment order.
allotment order.
Allotment order. Okay.
Now here again, the respondent is very strongly reliant on the survey report of the suit land in 2015. Now, even the plaintiff, the respondent, is not clear of the area, total area he is claiming.
The respondent also claimed that the claim of the right. The claim of the respondent is also based on the survey report. Based on survey report.
Yes.
So which is not
tallied with the original.
which does not tally with the original allotment or allotment, which is not tally with the area mentioned in the allotment, mentioned in the original allotment order. Okay.
Allow me to just make a clarification or just
yes.
on that. Regarding the order dated 25 May 2007, where my judgment, my landlord senior counsel has been mentioning that a similar case, similar and same, that is different, as you know. This is there in the similarity in the issue. Now, parties res judicata section 11 of CPC will apply only in the
Next paragraph. The land counsel for the appellant submits that since the so why it can't be,
lordship in the first
the
place.
parties are not the same.
Yes, I have also admitted before this lordship that we have not challenged this order. However, the applicability of this judgment in the present case.
The summary said although the order passed by the deputy commissioner on
25 May 2007.
25 May 2007 has not been challenged by the appellant, but the same cannot be relied.
Relied.
Okay, in as much
Or
as
applying them.
the same cannot be relied. And in as much as the parties
are different as well as the subject matter of issue is different.
same cannot be relied, and the principle of res judicata will not apply in as much as the part. Where is the
Parties are different.
in as much as the parties and subject matter otherwise is same in as much as the
Subject matter is not directly connected with the present issue. Parties as well as the subject matter.
parties are not the same. Parties and
The subject matter of the dispute.
parties and the subject matter of the suit land are not the same.
Yes, Lordship.
Okay, not the same.
Lordship, yes, in connection to that,
Hmm.
the learned court below has erroneously made an observation that we have produced the same documents.
Hmm.
As far as the Assembly of Union of India is concerned, there's a sketch map with the original we have. This is here incorporate all the area. This is under the occupation of the Assembly, and therefore it will be only one document, because this is inclusive all the present suit land as well as other parts, other area where the Assembly are under occupation, or the Union of India is under occupation. Now, my learned senior advocate has mentioned that since we have issued a same and the observation made by the learned court below has noted same documents. We have only one document,
Okay.
which clearly covers that all the area under
The
occupation.
Learned Council further submits that the appellant has only one document which covers all the land of the appellant, including the land claimed by the respondent and the land claimed by the respondent and the land claimed earlier by the district administration, Mokokchung.
Lordship, I have it next in my appeal memo also. However, Lordship,
However,
these documents which are referred is the land map showing detail of occupied land by Assam Rifles in Mokokchung town. This is very clear.
in one the said document shows all the land. What you say?
Yes, all the land under the occupation of Assam Rifle
Okay. So
at Mokokchung town.
all the land under occupation of the Assam Rifle, due to which the same document had to be relied upon before the be relied upon before the deputy commissioner in the case between the state of Nagaland, represented by deputy commissioner, versus the Assam Rifle, and in the instant case between the respondent and the respondent stroke plaintiff versus the appellant appellant respondent, appellant defendant within bracket in the trial court. Okay. We'll correct it later on. Yes.
So it's just the operative part. This is an exceptional case where the order, or rather so it was not challenged. Now this cannot apply because there is an observation made in the operative part of the judgment where my learned senior advocate has not touched on that. Now just in the last para, that is the same order. Lordship, I will just read out that
Yes.
land. This land has been earmarked.
Para-
That means the previous order judgment.
This is judgment.
This is judgment.
Okay, last
Yes.
para,
Last para. And in the last two sentences, Lordship.
last two sentences.
Yes. This land from this down from available in that. This land, Lordship, has been earmarked for construction of DC office complex.
This land, yes, this land has been
Earmarked
earmarked
for construction of DC office complex and is best suited for the construction of DC office complex since it is centrally located and is adjoining to the office of the Deputy Commissioner. The Deputy Commissioner Mokokchung should be able to provide alternate accommodation to the unit who are presently occupied in the said land in the land in question. Lordship, absolute decision was not given. This is an alternate arrangement. Now, whereas the present respondent claims on the basis of the allotment that individually claimed. Now, this was earmarked, although it was under the occupation of the position of the Assam Rifles, that is Union of India. Since it was earmarked because it is the most suitable area for coming up with a.
It appears that Deputy Commissioner has also admitted that it was under the position of the Assam Rifles.
Has been, Lordship, when you read the whole judgment, totally the history, because Lordship, we cannot pick and choose.
No. What he says is the Deputy Commissioner Mokokchung should be able to provide alternate. When you say
I don't have any legal right in all the
accommodation to the unit.
My lord, the question is, it is only a suggestion. By way of suggestion, I can give you alternative if you want.
This is an order.
But my lord, whether they have asked for it? So whether does it change the thing? Because Lordship, when the deputy state government passes an order, okay, I give you more if you want.
Okay.
What is harm?
Okay. Okay. So the next para, the Land Council for Appellant, while referring to the observation made by the Deputy Commissioner in his judgment and order dated 25 May 2007, where it says within inverted comma, this land has been earmarked for construction of DC office complex and is best suited for the construction of DC office complex since it is centrally located and is adjoining to the office of the Deputy Commissioner. The Deputy Commissioner Mokokchung should be able to provide alternate accommodation to the units.
Accommodation, Lordship, alternative site.
Yes, to the unit who are presently occupying the land in question. Okay, inverted comma close. So, in view of the above, the Land Council submits that admittedly, the land was under the possession of the appellant, and the land was given to the district administration with a view to give an alternate accommodation to the appellant, Assam Rifle.
Yes.
Okay.
My point is that therefore, risk to be considering that on the basis of the order passed by the Deputy Commissioner Mokokchung will not apply here in that case.
In view of the above, the principle of res judicata in the instant case is not applicable as not applicable. Okay.
Okay, to sum up, just to like emphasizing on that. Besides that, no issue has been decided.
Okay.
That we have been discussing more on that.
Okay.
Yes.
Okay.
Besides that, now
The Land Council for the Land Council for the appellant submits that the issue number 4, 7, and 8 has been discussed, but issue number 4, 7, and 8 has, although the issue number 4, 7, and 8 has been discussed by the landed trial judge, but there is no finding into the said issues.
and moreover, the respondent from the civil court, court below, while the proceeding was before the land court below, till today could not ascertain the actual area of the land. However, the land court below has passed a judgment on by giving another different area. So it gives a total confusion that what is the total area that they are claiming. Now, as I'm repeating the same thing, by the allotment, different area. By survey,
That is already recorded.
So, and the judgment, the decree was passed giving a different area. Now, there is no clarity from the part.
Okay. So, the learned counsel for the para, also submits that there is also no clear-cut mentioning of the area. In fact, the area, and in fact, the trial judge also under confusion and not given the clear-cut, sorry. So not given a clear-cut area of
Clear-cut
the
area.
suit lane.
Suitland.
And the claim of the plaintiff respondent hearing is different. The area claimed by the appellant respondent hearing is different, and
It's the area mentioned in the
the
judgment.
area mentioned in the judgment is different. And mentioned in the judgment and the decree are different. Okay.
Yes.
Okay. So you also
Yes,
give a small list of date.
my lord.
Okay. So that your submission, the list of claim would be also be
My lord.
mentioned. If you want some paragraph to be mentioned,
Lord.
just
My lord.
small list of date. Okay, list of date.
Well.
You also submit. So thereafter,
Yes,
I'll keep. So
my lord, small clarification,
yes.
small clarification on my learned submission because number one, lordship. My lord, the other day, I had made specific submission, but since your lordship is recording,
Yes.
my lord, the statements in my plain at paragraph 2 to 7, it is admitted by the respondent in paragraph 6 in the written statement. On the first day, lordship, I have given this submission.
Yes.
The statements in my plain at paragraph 2 to 7,
In your plaint
yes,
earlier,
in the trial court.
plaint.
Paragraph,
Where do we find?
my lord, lordship, may kindly see the plain, because it was shown to the,
From page number 34. That is a
my lord, the other day, this statement was given, but then since
Yes.
lordship may kindly see, paragraph 2 to 7, my lord. My lord, paragraph
It is
paragraph
at
2 to
page-
7, the descriptions, everything is given.
okay.
In the
It is
plain.
at page. It is at page.
My lord,
page number 35.
the plain is at page
34 from 30.
30, 34.
Yes. From 34. No?
Page 34, then my lord, the paragraphs is given.
34, 35 is.
35,
Paragraph.
lordship may kindly see,
Hmm.
all the statement which he has submitted is belied, but
Yes.
lordship may kindly see the paragraph 2. That is the description of the land.
Okay.
Then lordship,
Then-
paragraph
then-
3, how it was allotted.
Then it will be a submission of the appellant. Sorry, respondent.
Yes.
The case of the respondent is that paragraph 2 of the
Paragraph
paragraph
2 to
two.
7.
2 to 7.
Yes.
Page 35 to 37.
7.
Huh.
Then Lord, yes,
2 to 7 of the plaint.
yes.
2 to 7 of the plaint. Of the plaint. You have to type this one, para 2. But of course, not type. I'll have to dictate in that.
Yes. Then lordship, you kindly come to page 95 or 120, paragraph 6 of the written statement. It is admitted.
Page
Page
95.
120 or 95,
Yes.
paragraph 6.
Okay.
Not controverted, 2 to 7.
Okay. Then if further submit that the above claim of the plaintiff respondent hearing has not been controverted by the appellant respondent
In the affidavit, in
In,
written statement,
in their written statement
at paragraph 6.
mentioned at paragraph 6.
Then lordship,
The 6 of their written statement.
then lordship, paragraph
Just a
8,
minute, within bracket, page 95.
then paragraph 8 to 13, lordship.
Hmm.
Paragraph 8 to 13 of the plain.
Okay. Then again, next para. The land counsel for the respondent further submits that the sketch map in
Paragraph
this
8
one.
to 13 of the plain. to the
Okay,
plane.
this. Okay, paragraph 8, 9,
8,
10, 11, and 13.
12, 13, 8 to 13.
12 and 13.
At paragraph 10, at page 123, not denied.
Hmm?
In the written statement in the paragraph 10,
Ah. You have to type out this, huh? Okay.
paragraph 10,
Mm,
my lord,
And it is also 10.
yes,
Earlier it was 8. Earlier,
earlier it was 6. Now,
it was 6.
in reply to paragraph 8 to 13, you have replied in paragraph 10 in the written
And the above,
statement.
and submits that the above claim of the plaintiff responded herein has not been controverted and
Paragraph 10,
by the respondent appellant hearing, huh? In their written statement
at para 10.
at para 10,
Then,
within bracket, at para 10, within bracket, page 98.
then Lordship, paragraph 14 to the plain, paragraph 14 to the plain
Hmm.
is not denied at paragraph 12, page 9.
Okay, further, huh? Next para, huh? Next para. The counsel for the respondent submits that the paragraph 14, huh? 14 to
Paragraph 14 to the plain is not denied at paragraph 12 of the written statement.
paragraph 14, huh? Paragraph 14.
And finally,
Next para, the above paragraph 14 has not been denied in
paragraph 12,
denied by the appellant respondent, denied by the respondent appellant hearing in their written statement at paragraph
12.
12.
Then,
Just a minute, 12, huh? Within bracket, page 99.
then finally, Lordship, the statements made in paragraph 15 to 24.
It is further submitted that paragraph 15
to 24
24
to the plain has not been denied at all.
to the plain, huh? Page 40 to 43, huh? Next para, the above paragraph, the above claim of the plaintiff respondent hearing has not been denied by the appellant respondent.
In the written statements.
And denied by the respondent appellant hearing in their written statement at para.
No para,
Okay.
don't be silent.
Okay, denied by the appellant, stop, appellant.
So, my lord,
Okay,
so my lord, the issue is the whole plain was not denied before learned court and what survives.
okay. So it is further submitted. Since the whole claim of the plaintiff respondent hearing has not been denied by the respondent appellant hearing
In the written statement.
in their written statement in the trial, before the trial court. And nothing survives, no?
Yes,
Okay.
that is my first.
Okay.
Secondly, Lordship, because this was submitted the other day on 13, but since
Yeah.
your Lordship is recording for your
Just for my,
Yes.
because this will be dictated later
That's
on.
why I'm,
This is for reference.
to
only.
save time, I'm repeating that.
Yes.
To his reply,
Hmm.
my lord, lot of issues has been raised on the discrepancies of the allotment orders and things like that.
Hmm.
But subject to repetition, in the plain, everything is mentioned, not denied.
Right, right. Hmm.
Secondly, my lord, parties are confined to their pleadings. So in your grounds of appeal,
Hmm.
in the grounds of appeal, the submission that my learned friend has made just now on the discrepancies on that there are three different measurements on the allotment
Right,
order
right.
and all that. Those are not grounds of appeal. Lordship, 13 grounds of appeal, so nothing is mentioned there.
Hmm.
So when it is not a ground of appeal, whether this honorable court can accept the submission because parties are bound by the pleading that is
Okay,
called
the
the rule
learned
of law.
counsel for the respondent file submits that the submission made by the learned counsel for the appellant that there is a discrepancies in the measurement of the suit lane in the original allotment order, in the survey report, and in the impugned judgment are not the grounds for appeal,
Yes, not grounds of appeal,
not the grounds of appeal,
nor in the written statement.
nor in the written statement. Hence, the same cannot be discussed and decided,
Yes,
discussed by this court.
yes. It's
Discussed-
beyond the purview of this
decided-
honorable court. It is beyond the
discussed and
purview of this.
decided by this court.
Now, Lordship, another important issue is this.
Hmm.
My learned friend is raising a lot of, this is a repeated issue, subject to repetition. My learned friend, he is raising a lot of issues on the allotment order, settlement orders, and then the survey report and the eviction notices. But this is not the right forum to discuss these issues. The right forum, he should have filed a writ petition and challenge it.
That is there.
And it has not been challenged.
Fairly admitted in the last
Yes.
session.
Last occasion, he
No
has,
appeal file.
so no appeal for when it is not
That
challenged.
is there.
It is not evidence. So whether, my lord, whether that is not a subject matter of this court.
Hmm.
Because it is not a computer, because they have not challenged. So when that is not challenged, my lord, whether this honorable court should waste its precious time on those issues, which has attained its finality because they have not challenged. That is the basic issue. The other day, last occasion, so 13.5, on 13 May, Lordship was repeatedly asking why you did not challenge. And when that is not challenged, and that was the basis of my claim, and that was recognized and given to me by the lower court below, by the trial court. Trial court simply says the title given by the allotment order is final, so title and position.
The learned counsel for the respondent further submits that the allotment given to the respondent plaintiff
That's all.
has not been challenged by the appellant. Okay, this is the only point.
Yes, then,
I'll elaborate.
my lord, on issue of res judicata, my learned friend, I am reading it again, subject to,
Have been challenged by the appellant till there. Okay.
my lord, I am reading this one, just one sec,
Hmm.
for you, so since this is an issue.
Yeah.
No court shall try any suit or issue in which matter directly or substantially in issue has been directly or substantially in issue in a former suit between the parties,
Yes.
or, my lord, this is,
11.
oh, yes, between the same parties or between parties under whom T or any of them claim litigating under the same title. So it is between the same parties or any other parties who are litigating and claiming under the same title. So, my lord,
No, this may not be.
so the
Because-
same
because-
title,
Because what the lane claim
my lord.
by you and the district administration is altogether
No, that
different.
is
You are
issue.
claiming a
No,
different
no,
name.
no. The issue is
Claim
this.
different.
The issue is, it is same title.
Hmm.
And that is why I'm repeating it. It is same title. My lord,
It cannot be.
please,
Yes.
my lord, just 1
Yes.
minute. For my personal satisfaction.
Yes.
You may not agree or agree, but my personal satisfaction.
Yes.
My land is just a plot of land,
Hmm.
100 by 100, 100 by 110, 73 by 65.
Hmm.
A small portion of land.
Hmm.
Under the plot of land, big plot of land,
Hmm.
which is under their occupation, which they claim to be under their occupation. It is a portion of that same title. My lord, A is an area that is the TC Hills. They are saying it is compensated land by 100 rupees. They are claiming possession, all that. For last more than 100 years, they are in possession, and then the survey may conducted. All is treated as one. Now from there, my lord, from there, a portion of a small plot of land is now for construction of Deputy Commissioner's office. A small portion, 100 by 100 or something. Now from that big chunk of land, under one title, my lord, I am claiming this is not part of yours. Then I'm claiming 100 by 110, 65 by 73 feet. Small plot. From that big plot, one title, which they said they have been in occupation since 1889 under TC Hills. So the title is one. All are under one title. However, from that title, Lordship, they are claiming that all belongs to me. But I'm saying that this portion does not belong to you. The state government also came and says that from that title, this portion does not belong to you. It is for construction of TC's office. I'm saying this is private land. Title is one. They are claiming one title. They are not claiming 9, 10 different plot of lands. They are really claiming one. Yes,
The Land Council for the respondent for some is that the appellant is claiming only one title over the lane,
entire land is
over the entire lane
at TC Hills, Mokokchung.
at DC Hills,
Yes.
DC Hills, Mokokchung, and from out of the said large chunk of the said lane, the deputy commissioner in DC versus in the state of Nagaland versus Assam Rifle has decided a portion of lane to be the lane of the district administration, and from the same title, the present respondent,
Yes, President.
respondent is from the same
Lot of land.
plot of land, the present respondent has a claim over the lane around claim over the lane
110.
around measuring around
But Lord, it is there.
100 into
110 into 110,
100 into 10,
65, 73.
100 into 10 into
100 into 110 into 100 into 65 into 73.
okay.
Feet.
Could you write?
It is there in the map.
Okay.
In the allotment order, it is there, Lordship.
Okay.
Settlement order, it is mentioned there. The specific area.
And since the lane claimed by the present respondent and the district administration are from the same lane,
Over which they are claiming title.
over which the appellants are claiming title, the
Principle of res.
the principle of res judicata will apply.
Yes.
Mm.
Much obliged, Lordship.
Okay.
Lordship, allow me to make a clarification.
Yes.
Just specific clarification.
Clearly
Has
mentioned,
mentioned
respondent.
that it is some chunk of area which is under our occupation. And tomorrow, another person from other corner come and claim
That is there. I have understood.
whether that's reciprocal will apply.
Yes, yes. No, it's
yes.
submission only.
Yes.
It
As
is
far
submission
yes,
only.
as far as the suit lane is concerned, the author passed in 2007, 25th May by the Deputy Commission falls under different area and the present suit lane is different.
Yes, we have
Yes,
recorded
yes.
yours.
Yes.
It's a different area because that cannot be why I'm saying is because that cannot be. I just told.
Yes.
That cannot be because the lane is different.
Yeah.
So from same person, different 10 person may claim. 10 person may claim from the same lane. Okay, that cannot apply to the other one.
I'm only replying to his submission.
Yes, yes.
So-
It's only submission. That is why.
No,
That
I think to
becomes-
make
it's only submission.
falls under different.
Yes, and then so this probably you have submitted the judgment.
The only issue is
Ah,
under what title he's claiming. He's not till now. I have listened to him for last 2 days. But till date, he's not able to show any document evidence under what title he's claiming.
Your measurement also not clear.
Yeah.
Yes.
There is
Nothing.
a clear measure
Why not
that
first?
the present suit land
Ah.
falls under DAC one,
Ah.
which is 1.8 acres.
Yes.
Because it is
1.8 acres.
1.8 acres.
So no proper measurement as such.
1.8
Okay.
acres.
Okay, the land council.
The suit
It
enforcement.
is in the plain. I think in the.
It is also in the plain.
It's there only.
Yes.
First, he should
Which
prove his
para,
title.
Which para you?
Well, 2 to 7. In 2 to 7, all the descriptions are there.
Okay, that's fine.
And which he had admitted.
Your all the description
Yes.
in the para 2 to
2 to
7.
7, everything is there. Mostly it's read para 2.
Yes.
Right.
Annex A, page number 103.
Everything is there, and which he has admitted. So
No. Your
Alright.
claim, your claim.
Yes, Lordship.
Malab, when para 2 to 7 to the plain is admitted, what is left?
No, that is your submission, of course, and then that is admitted also. But then now claim before
It is, Malab, in the regional statement they have admitted, so it is not
Yes.
sufficient.
that is that will be there, but then their submission will have to be recorded in the appeal. Where have you stated?
Annex A.
In the appeal also, I have not
This
found,
is
Lordship.
decree.
Not there, it is not there. I have gone through 13 grounds, but it is not mentioned. Because his ground starts from page 8, para 14. Para 14 is his grounds. It should be there. Page 8.
Page 8.
Yes, paragraph 14 onward, the grounds are given in Roman letters, about 13. So beyond that, he cannot go.
Your
Beyond-
claim.
Beyond that, he cannot go. That is what I am submitting, Lordship. Beyond the 13 grounds he has given, grounds of appeals, para 14. Lordship, may kindly go through the grounds, the 13 grounds
Yeah,
minutely before we pass that.
that is there. So he is claiming these on these ground. So let me suggest.
It is not there. They
Okay,
didn't
that's
show.
fine.
They didn't show on the grounds.
The documents which the sketch map.
No,
which of
he
the-
cannot go. Principle, golden rule of bleeding. He cannot go beyond his
Lordship,
bleedings. The grounds are there.
This is decree.
Malab, the Lordship Mekani says grounds of appeals.
Just a minute. Para 4.
Paragraph 4 of
Your appeal.
no, my lord, we have to see the grounds. Page 14, paragraph 14.
That is ground.
Grounds of appeals. That is the grounds of appeals start from paragraph 14 only. Lordship, the
Yes.
13 grounds are given grounds.
Yes, that is there.
I should not be taken, my lord, is a established principle that beyond the grounds, he cannot go. Otherwise, he should not ambush me.
Yes.
He should not ambush me beyond 13 grounds.
Yes. Okay. Okay.
Notice,
So-
para number 4, yes.
Okay.
One para number
So,
4.
Hmm.
Then mention it also.
Yes, so on Monday, both will submit the
Yes.
list of that.
Yes.
No,
Yes.
so
We can, Lordship, we can submit on Monday to your PS in the office instead of
Hmm.
in the open court, or
Hmm.
not be listed again.
just submit, we'll list it only. On that day, I'll keep CAV
Okay.
because in the.
Otherwise, Lordship, you pass an order today, to
Hmm.
pass CAV, and parties are directed to submit
No,
your
because
list.
date is counted because I have Samara CAV.
Okay,
So
Lordship.
so date is counted. So
I
on Monday, I'll
I
keep
appreciate
CAV.
that. Fine, Lordship, okay.
Okay, so. Okay.
What you doing?
Okay.
When you submit.
Mr. Yeah.
WR.
Yes. Council,
The rest
Oh.
is GSC.
CGS.
the CGSC. For the appellant, huh? Also heard. Mr.
Takamasa,
Takamasa, National Council,
assisted by Arano.
Mr. Arano. National Council for the respondent.
Respondent plaintiff.
Respondent. Plaintiff, okay, respond, staff. So only on
Hearing,
that day,
hearing concluded,
I'll carry.
listed for, on Monday for submission of list of dates.
Okay. Hearing concluded, huh? Okay, that was just a minute, huh? This matter on Monday for further clarification, we'll say.
Yes,
Okay, we'll not say that.
okay.
So on that day, I'll carry.
If it is specifically passed as a part heard.
As part hard. Huh?
Yes.
So this is only for submission.
Yes.
Unless there is, of course. In
No,
the
my lord.
meantime, I'll try.
Yes. My lord, we'll only submit the list of dates. that-
Yes, okay, and then copy, I think you have already submitted. Copy of the judgment.
Yes, lordship,
Yeah, okay.
those copies, only the one which we have placed today before
Yes.
your lordship.
Okay.
That has to be kept.
No, this. Yeah?
Yes, that one.
Okay. So,
Lordship, we are very thankful for a very patient hearing. We have really enjoyed. We have really enjoyed.
for cooperation,
Yes.
for proper assistance. Yeah? So assistance. Okay. So this probably you give it to in a chamber. Okay, submit it. Or you type whatever I have dictated. Okay.